Hi everybody, I Kumari Akancharai in front of you to present assignment project which I have been allotted by my professor to present the assignment. The topic is doctrine of Ejusdem generis, of this subject the interpretation of statutes. It's a very generic, it's a very specific too. So generic in the sense that judiciary always use this for the interpretation of statutes and laws, and specific in the sense is this, that it can only be used in certain circumstances. So doctrine of Ejusdem generis is the rule of interpretation through which the judiciary interpreted the laws. Now moving forward, we must be knowing that what is the meaning and definition of Ejusdem generis. Ejusdem generis is a Latin term whose meaning is that of the same kind or nature. Anything which is mentioned. If the judiciary is interpreting or finding out the meaning of that word or text, then judiciary have to be focused on the thing which is already existing, which is of same nature, which is of like nature. So by this way, Ejusdem generis concept gets applied. According to Black Law Dictionary, the principle of Ejusdem generis is where general words follow an enumeration of persons or things by particular and specific words. Not only these general words are construed, but also held as applying only to persons or things of the same general kind or species or class. Same as specific. So this is the motive or the wisdom of the judiciary to find out that whether it belongs to the particular class or not. The doctrine of Ejusdem generis provides that when a list of a specific word is given, then you have to interpret the word which is just following the same meaning of that in light of those lists only. In other words, we can say that where a law lists specific classes of person or things and then refers to them in general, the general statement only apply to same kind of person or thing specifically listed. So general applicability can only be done in light of or by virtue of things which have been already mentioned. आगे हम जानेंगे. In this presentation I will show that on what condition the Ejusdem generis concept would not be applied, meaning thereby that if there is no specific list which is mentioned by the legislature, so on the interpretation of a single word without having any exhaustive list earlier, Ejusdem generis concept would not apply. So very important it is. Let's focus. Case which is important into it is Evanas versus Cross. In that case, first time the concept of Ejusdem generis evolved in interpretation of a term known as other device. Other device term was interpreted by the court in light of different terminology which was mentioned in section 48 clause 9 of Road Traffic Act 1930. So all signals, warning, signal post, sign or other devices, such things were mentioned. The court had to interpret other device. So other device was interpreted by the court in light of already mentioned words, but court was of opinion that the term painted line on the road would not be counted as a other device because the word mentioned already is not fulfilling the same criteria over which the painted line can also be considered as the part and parcel of other device. Next, why we need this doctrine? So we need to interpret the statute or law. We need to clarify the ambiguity, unclearance, absurdity into the language. When there is a possibility that there can be two meanings. So it's the duty of judiciary to find out the most relevant meaning of the particular statute or law. Meaning which the provision of statute gives defeats the purpose of the statute. If, for example, if judiciary is interpreting a matter and the meaning which is coming out of that interpretation is not that much effective, is not fulfilling the desired notion, then it's the duty of judiciary to apply the concept of Ejusdem generis to find out the true meaning, purposive meaning, purposeful meaning of that statute. So there is no need for interpretation if the language there is no ambiguity and no unclearance. So this concept would not apply. Now when it applies, there must be certain condition on which this act or this rule could apply. So unless the context required, the natural meaning should be given to general word normally. Supreme Court Lilavati Bai versus State of Bombay case में कहती है, given the context and the object of any statute or law is clear, whose meaning is possible by applying the literal and grammatical interpretation rule, then Ejusdem generis would not apply. It would only apply in the case when there is absurdity, ambiguity, if there is two meaning, more than one meaning, and that meaning is not appropriate. So then only justum generis concept would apply. After reading the statute, it has been found that the provision is showing certain ambiguity. Provision is mentioned categorically in such a way that it's not clarifying the intention of the legislature. So the justum generis rule would apply to find out, because it's anything which is going with the same nature, same kind, same preferences, then it would be preferred. When general word follow the specific words, and those specified words have a genus category, we will move forward and we'll find that there is two things which need to be focused by the judiciary. First one is the class and genus of that word which needs to be interpreted, and secondly the intention of legislature. What was the intention of legislature behind that word incorporation into the legislation or the statute or the law? So if that particular word is belonging to the particular genus or class or category, then only in light of those mentioned words already, that specific word which needs to be interpreted would be interpreted in light of those words only. Ejusdem generis, a facet of nociter associis. It's another Latin term, or it's a maxim, by the way. It's a part and parcel of secondary rule of interpretation. Meaning of the nociter associis means in association with, in the society of. So it has been considered that the doctrine of Ejusdem generis is the part and parcel or facets of this maxim, nociter associis. Because we know that there is a class, there is a category of certain words, things or person. In light of those category, one word is need to be interpreted. So in association with that, if you are interpreting a word, that would be counted as a part and parcel or facets of nociter associis, and which has been held into the various cases, and it was the Maharashtra University of Health and other verses Sachitikishan Parasar Mandal and other verses and others 2010 का ये case है जिसमें the court has observed that how a justum generis concept or rule could be the part and parcel of nociter associis. Essentials of doctrine of justum generis. In our leading case, that was of Amar Chandra Chaturvedi versus Collector of Excise, and second case was Uttar Pradesh State Electricity Boards versus Harishankar. In both the cases, court had formulated four or five categories or essentials of Ejusdem generis, and one of those is the statute contains an enumeration of specific words. Subject of enumeration constitute a class or category, as I had already mentioned. Class or category is not exhaustive because it is up to the wisdom of judiciary to find out whether it would go in that particular class or category or not. General terms follow the enumeration, and there is no indication of a different legislative intention. Most important. If you are interpreting a word which is going against the legislative intent, that word would not be counted as a valid word, because we have to be focused on the intention, objective, aim of the legislature, with what objective legislature came with that provision. Class or genus of a specific word is very important, then only judiciary can interpret that particular word in light of all those class or genus. Intention of legislature is very important while interpreting or applying the concept of Ejusdem generis. Next, landmark judgments are Siddheshwari Cotton Mills Private Limited versus Union of India. This PPT has already been transferred to my professor, and I am just explaining that out. In that case, what happened, that a word was there which was about to be interpreted by judiciary, that was any other process. So to interpret any other process, I would go with an example of Article 12 of Indian Constitution. Article 12 of Indian Constitution defines a state. So what is the state? State is Government of India, Parliament of India, Government of State, Legislature of the state, local authority, and any other authority. So above 5 is very much clear. But this term other authority is ambiguous, not clear. So it's upon judiciary to find out, to interpret this term other authority in light of already mentioned under Article 12 of Indian Constitution. So similarly, in that case, any other process was about to be interpreted by the judiciary, and that interpretation was in light of bleaching, dyeing, printing, waterproofing, and many more. So court interpreted it in light of that only. Next, we can move that what are the limitations or applications of this rule, because it's not a general rule which could be applied by the court in any or each or every matter. So as I had already told, that where there is a specific word, single word, that specific word or single word is not to be interpreted according to Ejusdem generis. There should have a class or genus prior to that. if the specific word in provision of statute which have been followed by the general word do not form a distinct genus class, it would not form a distinct genus class, then you are not bound to apply this rule. Next we have is doctrine of Ejusdem generis can't be applied if the general word follow any one word or one category. I had already mentioned. Next, there is a very cautious approach while applying the rule of Ejusdem generis. So you have to be cautious. There are very lacunas, or there are very disadvantages of this act of this rule also, because when we apply the concept of Ejusdem generis, it's just fixing a boundary, limiting the wisdom, narrow interpretation some or the other way. It's proceed towards the aesthetics, because we know that law is life. If law would become statics, either it's a judgment law or the legislative law. So it's fatal for the society or societal change. It's against the dynamism. So these are the backward of this, these are the disadvantages of this rule also. Now conclusively, I would say that this rule of Ejusdem generis is the part and parcel of secondary rule of interpretation. And while interpreting, while applying this rule, judiciary have to be very conscious. Judges have to put forward in their eyes whatever the requisites of applying this rule. And it can only be applied if the literal and grammatical meaning is not sufficient to provide the true and proper meaning of that text. So this is the prima facie presentation, or the concept or detailing of, you can say, of this doctrine of Ejusdem generis, which I can present. Thank you very much. I hope so that it is informative. Thank you.